Everyone. Welcome to today's immigration podcast, where we thought that it would be interesting to focus a little bit on sponsor license compliance. I think what we aim to do is we'll run through some recent changes that we're seeing in practice. Have a little bit of a brief introduction as to kind of why we're talking about this. What we're seeing in terms of the increased scrutiny surrounding obtaining a sponsor license, sponsorship license duties in general, and the record-breaking numbers of sponsor licenses that are being revoked from businesses who are found not to be complying with their sponsorship duties. So I thought I'd start by way of a bit of a background. The Home Office have always made it completely clear that sponsorship is a right. Is not a right, rather. It's a privilege, not a right. So in granting a license to an organisation, they are signing up to play their part in ensuring that the immigration system, the UK immigration system as a whole, is not abused. That sponsors are responsible businesses, ensuring that they're complying more generally with wider UK laws and don't really conduct themselves in a way that wouldn't be, that isn't conducive to public good, to take the wording from the guidance. So in essence, they want to make sure that any overseas nationals that sponsors are employing meet all of the relevant eligibility requirements for sponsorship, and the sponsor genuinely wishes to employ or sponsor them. So on the flip side, any sponsors that fall foul of any of that, so any sponsors not complying with the rules, their sponsorship duties, will face some kind of action. So whether that be downgrading of a sponsor license, what that means, a downgrading would mean that the sponsor would be severely restricted in being able to sponsor new workers for a limited period of time to allow them to then become compliant. Then hopefully that rating goes back up to an A, and then they could continue as normal. So what the problem is, and what we're seeing is that we're seeing more cases of the worst case scenario. So more of a readiness from the Home Office to not downgrade licenses, but to revoke them altogether. So perhaps that's a good opportunity to bring you in, Alex, and perhaps we can run through some of the recent statistics that we've seen from the Home Office of interest to not just current sponsors, but those who are kind of looking to apply for a sponsor license more generally.
Yeah, thanks, Rebecca. Yes, I mean, I think this thing that sponsorship is a privilege, not a right, it in a way gets my goat up, if that is that the expression, but it gets my back up, because it's a thing that the government likes to say about a range of things, and I suppose it actually gets my back up more when they say that citizenship is a privilege, not a right, which is something they've backed off of saying a bit more recently. But it's true to say that it's not a right to hold a sponsor license, and it's true to say there's an element of it's in some ways voluntary to hold a sponsor license. But there's a lot more to it than that, actually. We're planning to talk about that later, but maybe to lay a bit of the groundwork first. Look, in terms of statistics, it's really stark. So if you look at the number of applications for sponsor license, I thought it'd be interesting to look at, well, how many sponsor license applications are there? I remember when I started practicing in business immigration about 2015, there were about 25,000 licenses, and now there's over 125,000. It's just exploded literally in the last couple of years. I looked in preparation for this at some of the numbers of applications, and it was something in the region of about 7,000 applications for sponsor licenses a year, and it was trending downwards, which is what you'd expect, because large organisations, if they already have a sponsor license, they'll just keep it going, so there's no reason for them to apply again. But there'll be, some degree of churn, but not that much. The numbers just explode after the end of free movement. Free movement ends at the end of 2020, and at that point there's about 6,000 applications in 2020 for sponsor license applications. Then it goes 16,000 2021, 2022 24,000, 2023 43,000, 2024 40,000. This latest year down to 32,000, but about 5 times, 6 times as many applications as in the before the current points-based system launched. So there's huge numbers of applications, and it's the other part, actually the source of this story of liberalisation and the large numbers of new arrivals in the UK. And then going together with that is the numbers of refusals, and here the statistics are also, this is me just reading out numbers, but I think it's interesting because it's just so striking. So the numbers of revocations of skilled worker licenses specifically, 2020 291, 2021 89, so a total collapse. And I don't know if you remember, there was a report, a critical report into compliance in around 2020, I think, during sort of one of the second or third COVID lockdown, I remember. And then a bit of a recovery, 2022 273, 2023 337, then 2024 just under 1,500, 2025 3,100, so already 10 times the kind of regular level, and 100 times, 30 times rather, the level of 2021. And then just in the last quarter, already January to March 2026, 1,700. So the numbers of revocations happening have just exploded, especially in the last 2 quarters, around about 1,500 per quarter now, compared to about 100 per quarter. So we're talking about 15 times as many revocations as there were about 3 years ago. And it's really serious. I put in my notes, it's a bit like Chernobyl. Do you remember, I don't know if anyone's seen that show, where they're arguing about, is it 3.6, is it 2.5, or is it 3.6 Rontgen? And then they finally measure it, and it's 15,000 Rontgen. So it's actually hugely worse than you could have imagined. The Home Office don't really disclose what their reason, they don't really say what their enforcement mechanisms are, for obvious reasons. But my guess, and I think most people's guess, is that it's the main culprit is HMRC data sharing, because that's the thing that we know that the Home Office could easily scale. So it's a straightforward basis for revocation. You said you were paying your worker whatever it was, 40,000, but actually maybe the business wasn't doing as well as you hoped, and it turns out that you've been shorting them on their pay, and maybe they're being paid much less than that, and they're under the amount. Even if the amount that you're paying them would qualify, you could still lose your license, and especially if it fell below the minimum salary thresholds. And equally, simply, businesses might not be paying them on a regular basis, but the Home Office have brought in rules to deal with that, to say that essentially you have to be paying, you can't make up the shortfall later in the year. So that's a really easy basis on which they could revoke the sponsor license, because you're not paying them the amount that you said you would. And then it has these really serious consequences, as you'll know, when your sponsor license is revoked. So yeah, what are the implications of sponsor license revocation? Do you want to talk us through that?
Yeah, no, of course. I think, well, there are a wide variety of reasons why the Home Office would revoke a sponsor license. Things like seriously or systematically breaching duties, such as poor record keeping, failure to report changes of circumstances for migrant workers, for example, somebody's role has had a relatively minor change that doesn't trigger a new application, but those things are still reportable to the Home Office. Not undertaking right to work checks properly. So there are lots of different reasons that we're seeing in practice for revocations. But of course, one of the obvious ones would be, if a sponsor's ultimately found employing workers illegally, then I would suspect that would be we know that would lead to straight to revocation of the license. But what's really interesting about what we're seeing in practice is that the Home Office are becoming more hard line in their expectation around their reporting and various sponsorship duties, and we're seeing licenses being revoked in situations where in the past we would have expected the Home Office to give the employer the benefit of the doubt, allowing them to kind of correct their procedures where they've failed, to allow the business to continue to be a licensed sponsor, giving them the opportunity to become compliant and hopefully, along their way. But we have reasons to believe, as Alex, you said earlier, that some of the kind of increased activity around compliance and is by how do I put it? It is because of this information sharing that we suspect that's going on behind the scenes. We're seeing the Home Office increasingly contact sponsors requesting pay slips and P60 and other payroll information for their sponsored population to make sure that they are being paid at the level that's set out in the certificate of sponsorship, and where there are discrepancies between what is set out in the certificate of sponsorship and the payroll data that they're getting from businesses. If there hasn't been a kind of well documented reason for those discrepancies, then this could very much lead to a revocation of the sponsor license. So it does very much point to the Home Office and HMRC sharing information.
Yeah.
And so really, this is where record keeping. I know we say this all the time as immigration professionals, don't we, Alex? But this is where record keeping becomes really important. We've always advised to sponsors to ensure that they're keeping detailed records in line with their Appendix D obligations, but even more so now, and where you can explain a discrepancy. And if the more documented you are, the easier it is going to be to demonstrate to the Home Office that there's a reason behind it all.
And you don't just have to have the data, right? You've got to
exactly.
be able to produce it, because the
Precisely.
compliance visit, which will typically be Teams meeting,
Yes.
remote compliance visit, they'll expect you to, they'll put you on the spot and they'll want to know, well, how do you monitor this, and produce the documents for it. So you might have the data somewhere in your organisation, but you've got to have it in a way that's accessible to you and at your fingertips.
Exactly that. So coming then on to, what does it mean when you have a license revoked? Well, the consequences for both the employer in this situation and any current migrant workers working for an organisation that's lost this license are extremely severe. The employer will not only immediately lose their right to sponsor new overseas workers, the certificates of sponsorship for all workers will be cancelled and their leave curtailed to usually 60 days. And what that means is these workers during this period of curtailment will either need to find a new sponsor, quite difficult in a challenging jobs market, switch to an alternative visa if they qualify for an alternative visa, or worst case, they'll have to leave the UK. So really bad news. It also goes without saying that the reputational damage done to an employer when they lose a license can have far-reaching consequences for that employer. It potentially limits their ability to attract key talent, and there might be financial consequences as well, particularly for those employers who have historically relied on international recruitment. So on losing of the license, the employee is typically barred from reapplying for a sponsored license for 12 months. But we have seen it, for that cooling off period, for longer than the 12 months if there has been a particularly serious breach in compliance duties.
Yeah.
So I think perhaps moving on a little bit, Alex, there's been some recent changes, haven't there, to the sponsor license guidance, hasn't there, surrounding these issues?
Yes, so I guess this is the other reason we wanted to talk about it. Not only the tightening compliance situation, but the evolving guidance. I think they go hand in hand. So, I think when we talk about compliance, there's a range of things that the Home Office can do. So I was talking about this kind of explosion in numbers of licenses, and then following that, a sort of explosion in numbers of revocations. I mean, there's also statistics around the approval rate for licenses, which used to be much higher, and now it's sort of hovering around 50%. I mean, big picture, the things, the levers that the Home Office can pull when it comes to business migration, there's the level of scrutiny that they can apply to an initial application for a license. Then there's a level of scrutiny, as you mentioned, that they can make a further information request in response to a request for an allocation of COS on the license. There's the checks once you've got the license and you've got the worker that they might be doing with HMRC, comparing payroll information. There's the compliance visits, the number of those that they carry out, the level of information they require during those sponsor license visits, and then the decisions that they take at the end of it, potentially to revoke the license and to revoke all of the workers' visas and all of their family members. That should be mentioned. But so these are all variables, and the Home Office can change all of them. And I suppose what I was saying is that they've all changed in the same direction, which is to make it more difficult. I think for as long as I've been doing business immigration, immigration lawyers have been banging on about, it's becoming more difficult, but actually this time we really mean it, and the statistics do bear that out, that something big has happened. So I suppose the reason I went on that tangent is that the updates to the sponsor license guidance are a part of that whole story. So when the Home Office are taking these decisions to potentially to revoke, to either to refuse an initial license application or to revoke an existing license, they do so in accordance with their published guidance. And the story there in the guidance, again, I suppose another variable is the way in which that guidance is drafted and the extent to which it gives discretion to the Home Office to revoke or to refuse in a wider range of circumstances. And so that's all by way of preamble. But the recent changes to the guidance are on a similar theme. So just to run through what those were, there was a recent change to the sponsor guidance in relation to right to work checks that was kind of put in and then pulled back. I kind of see that as it's an early version of what's actually going to come down the line later, most likely in October. So long story short, in March this year, the sponsor guidance was amended to say that you have to do a right to work check on any worker that you directly engage. And they then took that back out of the guidance in May and said, no, we didn't mean that. But what they're really doing, or looking ahead to, I think, is the draft code of practice for employers on preventing illegal working, which has been subject to consultation since the Borders Act 2025 was passed, and the consultation there ended at the end of June, and the new regime will come into effect on the 1st of October. Essentially, the effect of that is to widen the statutory penalty regime for employing illegal workers. It currently applies to employees, and it's going to expand to cover a wider range of workers. So anyone covered under a contract of employment, so employees, but also people who are working for the business under a workers' contract or as an individual subcontractor, or who are engaged by the business via an online matching service. So it's essentially trying to capture so the gig economy workers. And workers of foreign national workers of businesses currently are not captured by the statutory the civil penalty regime unless they're an employee, and that's going to change on the 1st of October. So that's a massive change that's coming down the line. And I think the guidance changes, which were put in kind of a bit early, are going to probably be reinserted in October.
It's interesting, Alex, because, even before those kind of changes, or the changes that will eventually come down the line from autumn this year, us in the immigration community, there's always been a big debate about gig economy, and even though there was no requirement to do so, I've usually advised businesses that use contract workers and all the rest of it. I want to know the right to work status of anybody that's on my site, and that's often going above and beyond what was actually required in the first place. But it's now interesting that the direction of travel is now you need to do a right to work check on basically everybody.
Yeah, exactly. I mean, I agree. I think that's good advice, and actually it's borne out, because in the consultation, I think it closed maybe a week and a half ago. We're recording this the first week of July. I think it closed on the 30th of June, and the first question that they asked businesses was, who do you right to work check? And it turns out that 50% of businesses only right to work check employees, but another about 50%, or slightly less, already right to work check everyone, so workers as well as employees. So it's kind of a view that I think very sensibly businesses have already taken, and they will have to follow that approach from October. So that's one change. Then there's a few other ones that are coming in. So one that's probably more relevant to startups and SMEs and representatives of overseas businesses, I would say, rather than sort of very well established businesses in the UK. But where the Home Office introduced a new reason for refusal of a licence, where they have reasonable grounds to consider or suspect that the organisation has been established or exists mainly to facilitate the entrance, essentially, of a sponsored worker. That generated some interest and controversy from practitioners. In my view, again, that wasn't a big change. There was always a requirement that roles are genuine, and actually the wording that's been inserted kind of replicates almost exactly what I have been telling clients for years as an acid test of what genuineness is in the first place. More worryingly, they've got these new examples in the sponsor license guidance as to what they mean by operating or trading in the UK. So they give these two examples. The first is where they think you're not operating or trading is you apply for a sponsor license and you've set yourself up essentially as a company. You've got registered with HMRC for corporation tax, PAYE. You've got yourself a lease, maybe you've got yourself employer's liability insurance, but you haven't actually started trading with customers in the UK economy yet. And you're probably applying saying, well, we're going to do that, and this person's coming in and they're going to start the business. Now, it might be that you had a person involved in the business as a authorising officer or primary level end user who was a settled person, settled worker, but that's not enough. You actually have to be trading in the UK economy. You have to have customers and clients, so you can't have not started trading yet, essentially. So that was an important clarification. And then there's also a slightly more troublesome, I would say, bit about trading with related entities, and I think I can see what the Home Office are trying to do here, but I think it captures more than they intend. So what they say is, okay, you do have trade, but you've got trade with other entities that are linked to you by common ownership or control, and there's no evidence of providing services to other customers or clients outside of your organisation. And I think the worry there, they talk about sort of just moving money around, which could be what's happening, but there's also genuine arrangements where someone genuinely is working, but it might be sort of inadvertently caught by that. So I'm thinking particularly of transfer pricing agreements where, for example, a overseas business establishes an outpost in the UK and employs someone, for example, in a sales role, but they then engage any customers they engage contract with the overseas parent company, and therefore there's no direct trading between the UK entity and the UK customers, and the person who is employed under that sponsor license is then remunerated typically through a transfer pricing agreement, and that, I would say, is a genuine commercial arrangement, which exists, might exist completely independently of immigration considerations, but where the Home Office have said that they would consider that as circular trading. So we'll need to see how that sort of works out in practice. So those are some of the ones that are going to stay. I suppose I've talked about the right to work, which has climbed down. Then there was others that are more problematic, that I would say, again. So there were some additions to the sponsor guidance. One that was added in March is a requirement on sponsors to read the sponsor guidance in full, and they say that you need to read all of the parts of the sponsor guidance, parts 1, 2 and 3, plus all the appendices and the glossary and the guidance for the route under which you're sponsoring workers. And it's really handy because on the gov.uk website, if you just click into each of those pages, it tells you the number of pages in the PDF. So I did a quick count, that's 9 documents if you want to sponsor a skilled worker, and that is a total of 381 pages. And if you want to be even more exact about it, when they say you have to read, what they mean by that in the sponsor license guidance is anyone involved in the management of your business, and includes all key personnel, persons of significant control, and all owners. And it's difficult. It's really difficult as an immigration lawyer to say, well, they don't really mean that, do they? But if you read the guidance, it does say that's exactly what it says. So it's quite difficult to give the advice, well, it'll be all right if you haven't read it all. But that it says that they will. That they require you to do this, and moreover, it's a circumstance in which they will normally revoke your sponsor license if you fail to comply with any of your sponsor duties, which includes this requirement to have read everything. So that's a problematic, I would say, requirement that's been introduced. I'm not saying that I've seen and I've not heard of anyone license being revoked on the grounds that they've done everything right but they hadn't read all of the guidance, and I would be surprised to come across such a let's see what happens. I won't want to roll anything out. And then there was this other addition to the guidance in March, where the Home Office just essentially said, well, we require you to make your workers aware of all of their employment rights, and they give all these duties, so entitlement to national minimum wage, statutory leave, health and safety, trade union memberships, duties under the Equalities Act, a whole sort of range of rights and entitlements that workers have. That's fine, that is the law, and employers have to comply with that law, but that's very different from saying that employers have to advise their workforce on all of their requirements, all of their entitlements. So that would be saying that businesses have to go out and agree advice that they're going to give to all of their workers on what their employment rights are, and then deliver that advice. And so the Home Office just insert this obligation into the guidance, and then take it out again in May. So there was some sort of slightly embarrassing climb downs in the advice that we've had to give to clients. I suppose we shouldn't be embarrassed because it's not us doing it, but we're past. We're but the messengers in this situation. But yeah, I mean, I think what I wanted to work around to saying is that I think this idea that sponsorship is a privilege and not a right, that the Home Office say, well, yeah, the reason we say that is because sponsors have chosen to participate in this system of sponsorship. You don't have to have a license. You can choose not to have one. So if you do choose to have one, then you jolly well need to do all of the things that we say. That's fine. That sounds reasonable when you first say it, but actually you realise there's businesses that have had sponsor licenses since the points-based system was launched in 2008, 2009, and they've had populations of sponsored workers continuously since then. So they're not in a position just to say, oh, we don't want to have a sponsor license anymore. They are kind of locked into this system, and it's a system in which the Home Office has started to add these duties, perhaps without really thinking through what all of them mean. And so in a way, you kind of trap people inside the system, and then you're changing what that system is. Exactly. So I think this argument that the Home Office give that, well, it's all voluntary, and you could just choose not to be a sponsor. It's true as regards small organisations that don't already have a licence, but it becomes a bit less sort of apposite when it comes to long-established sponsors. But yeah, so it's an interesting one. I think we'll just need to see, if the Home Office will continue to make, as the Home Office continues to make the sponsor licensing regime more onerous and more strict, will this approach that the courts have always supported them in, that it's entirely a scheme that's entirely discretionary, it's created by the Home Office, they don't need to get statutory authority for it, and they can just amend the guidance at will. Will that survive the Home Office adding bits in without really thinking them through and without really consulting?
And I think my humble opinion is that all of this is acting as very much a deterrent, and specifically looking at businesses that haven't already been licensed, that might be looking or might be thinking about it. I think this will put off some businesses that just don't want to have to sign up to the onerous nature of what comes with being a licensed sponsor, and perhaps maybe feeding into the current agenda of reducing net migration. Who knows?
Indeed.
My humble opinion. Anyway. So, I think that's all we really wanted to talk about, wasn't it, Alex?
Yeah.
Just to kind of round up, I just think, sponsor, the Home Office are taking compliance very seriously, and we're seeing that kind of playing out in practice. So I think, just as a closing comment, it's I think it's, as it's becoming increasingly more onerous, I think getting proper advice or knowing exactly what your duties are even more important these days. And if in doubt, do get that specific advice. And that's it, really. So just to say thank you again for joining us on today's episode. I hope our discussion has helped you better understand sponsor compliance and the backdrop of what is becoming a more and more tricky system. If you found it useful, please do subscribe to the podcast and share it with anyone who might be interested in what we discussed today. Thank you again for listening, and hope to see you next time. Thank you.
Thanks very much.